Ruth Bader Ginsburg, standing only 5 feet 1 inch tall with big gray eyes. Her love of justice was grounded in persistence faced with adversity, with a disarmingly sharp but unaffected intellect, and with a deep-seated integrity that ultimately brought her life's work to public prominence, popularity, and greatness that she never wanted or expected. RBG was born into the life and culture of Brooklyn in 1933. Her childhood was marked by hardship, including the loss of her older sister, as well as the death of her mother, who passed away the day before Ruth's high school graduation. The loss of her mother in particular motivated Ruth Bader to achieve the highest level of success possible for herself, and ultimately for millions of other women. She started her higher ed journey at Cornell and went on to study law at Harvard and graduated from Columbia, even as she was raising a child and supporting her husband Marty, who was diagnosed with and recovered from cancer. At one point, her professor invited the few women law students at that time and asked each of them to explain how it was that they were willing, by their presence, to deprive a man of the opportunity to study law. Ruth Bader Ginsburg secured her first clerkship in 1961, and after a few years, she started teaching at Rutgers Law School in 1963, which was where she began her work fighting gender discrimination. I've recently come to understand that RBG never saw herself as fighting for women's rights, but instead fought for equal access to citizens' rights. Ginsburg fought for federal law to be applied equally across genders. She wrote her first brief for the Supreme Court in the 1971 case, Reed v. Reed, which was the first time that the Supreme Court had struck down a state law because it discriminated based on gender. Famously, in Frontiero versus Richardson, she quoted the 19th century abolitionist Sarah Moore Gimke saying, "I ask no favor for my sex. All I ask of our brethren is that they take their feet off our necks." The true nature of the arguments of the time is even hard to conceive of today. Before Reed v. Reed, Ginsburg wrote later, "Neither legislator nor judges regarded gender lines as back-of-the-bus regulations. Rather, these rules were said to place a woman on a pedestal." Although Ginsburg liked to say this was more of a cage pretending to be a pedestal. In 1980, Jimmy Carter appointed Ginsburg to the U.S. Court of Appeals for the District of Columbia. And 13 years later, in 1993, Bill Clinton nominated her to become the second woman ever appointed to the Supreme Court. In her acceptance speech, she thanked her mother, who she said was the bravest person she had ever known. "I pray that I may be all that she would have been had she lived in an age when women could aspire and achieve, and daughters are cherished as much as sons." Among her many important decisions, she gave the majority opinion for the court in United States versus Virginia Military Institute, which effectively strikes down any law that denies women full citizenship stature. Justice Ginsburg wrote, "Equal opportunity to aspire, achieve, participate in, and contribute to society." Ginsburg's integrity, intellect, and wit allowed her to rise above the partisan. Despite being on opposite ends of the spectrum politically, Ruth Bader Ginsburg maintained a close friendship with Antonin Scalia. There's a famous photograph that I love of the two Supreme Court justices riding on an elephant together, and an American opera called Scalia Ginsburg, which was created based on their playful relationship. In these polarizing times that we live in, we can use their friendship as an example of how we can come together by listening to differing points of view. I love the book, The Notorious RBG, a superhero who has inspired millennials and Gen Z youngsters. My daughter wears an RBG t-shirt with much enthusiasm. A whole new generation of women and girls have been exposed to her important work through countless memes and the 2018 documentary RBG, as well as the witty and insightful prose of her legal opinions, which will live on forever and inspire generations to come. It should by now come as no surprise that when we lost Ruth Bader Ginsburg a few weeks ago, I knew we had to do something very special to remember her bravery and her commitment to building a better world, a stronger world. Well, actually, I picked the faculty leads from our Women's History Month celebrations, Professor Erin Miller and Professor Olivia Garcia, as well as our students in the pre-law program, and together, this team created BC's retrospective on the life of Ruth Bader Ginsburg, a cultural icon, a champion of gender equality, who never stopped fighting for what she thought was right, down to her final day's last breath. Enjoy this programming.
She's known to many as the U.S. Supreme Court Justice Ruth Bader Ginsburg, but to others she's RBG, or the notorious RBG. And then there is the legendary declaration of I dissent on cases that she strongly opposed, earning her a following among the vibrant younger generation. At 5'1", RBG was larger than life, an influential powerhouse who left us too soon at the age of 87 on September 18th. Yet the Supreme Court Justice of towering stature gifted us with a legacy of law, justice, equality, and an inspiration for many to follow. RBG will be remembered for bringing women and gender equality to the forefront, something she began doing from day one, way before her prestigious appointment on the U.S. Supreme Court Justice. And to define her is difficult. She was many things to many people. Yet we can highlight to a moment from a few years ago when she received the Radcliffe Medal at Harvard University. And she shared a piece of advice to young college women. She said, "Fight for the things you care about." She knew this story all too well. RBG was a teenager when she lost her mother to cancer. And though she was selected to speak at her high school graduation, she missed the pomps and circumstance, having seen her mother buried the day before. And what should have been a celebratory high school graduation day, she grieved with her father and remembered her mother, one who left her with some great advice: be a lady and be independent. Many agree her mother's spirit kept her pushing forward. In 1950, she enrolled at Cornell University, where male students outnumbered women. And there she met the love of her life, Marty. The two married in 1954, and after Cornell, she went on to Harvard Law School, then Columbia Law School. Her marriage to Marty defied stereotypes, and equality rang through the home in many forms, including both leading successful careers, both supporting each other in many ways, and him being the house chef. At one point early in their marriage, Marty fell ill while in school, and RBG pulled triple duty with his schoolwork, her schoolwork, and caring for their then 3-year-old daughter. Her husband passed away 10 years ago, leaving behind a letter that said, "I have admired and loved you almost since the day we met at Cornell some 56 years ago." After graduating at the top of her class from law school in 1954, RBG found herself looked over by law firms that chose not to give her a time or day, likely the result of being female. But as she's been known to say before, and I quote, "So often in life, things that you regard as an impediment turn out to be a great good fortune." RBG became professor at Rutgers and Columbia Law Schools, and also began her work with the American Civil Liberties Union, where she successfully argued 6 cases before the U.S. Supreme Court, 5 of which were won. In 1980, she was appointed to the U.S. Court of Appeals and then to the Supreme Court in 1993. Before stepping into the Supreme Court, the Brooklyn native took on a variety of cases on gender discrimination, one of which landed in the Supreme Court. The Reed versus Reed in 1971 challenged the idea that a father had precedence in administering the estate of a passing child. It was a landmark victory, one she wrote the majority opinion, and one that relied on the Equal Protection Clause of the 14th Amendment, a constitutional amendment RBG took to heart in other cases before and during her term on the U.S. Supreme Court. While on the U.S. Supreme Court, some of her well-known cases have included the U.S. versus Virginia in 1996, which struck down the military college's male-only admission policy, and Ledbetter versus Goodyear in 2007, the unsuccessful case that sought to prove discrimination in equal pay. This is also the case in which Ginsburg issued her dissent, alluding to Congress to act, which they did, with the Lilly Ledbetter Fair Pay Act in 2009. In this program, you will hear from our judges and participants as they highlight opinions and dissent of cases that define the notorious RBG and her impact on them. I hope you will enjoy.
Can one person truly make a difference in the world? The answer is a definite, unqualified yes. When one examines the remarkable life of Ruth Bader Ginsburg and the contributions she has made to the American legal system, and thus by extension to our American way of life, the evidence is overwhelming. To illustrate my point, permit me to provide context to this assertion. I argue that there exists a strong correlation between a quality life a society provides its citizens and the active role females play in that society. I have chosen to focus on one Supreme Court case wherein Ms. Ginsburg, as an attorney, persuaded the Supreme Court to reject a law that discriminated against women. In Reed versus Reed, the facts are straightforward. Sally and Cecil Reed adopted a son, Richard, who died under unfortunate circumstances in 1967. Sally petitioned the probate court to be appointed administrator of their son's small estate. Her estranged husband, Cecil, also petitioned the court for the same appointment. The probate court ruled that despite both Sally and Cecil were equally qualified for the appointment as administrator, Idaho law mandated that males be selected over females. Sally appealed this decision all the way to the U.S. Supreme Court. Ruth Bader Ginsburg wrote a friend of the court brief analyzing the relevant facts and law. This brief came to be known as the grandmother brief because lawyers for years following the Reed case borrowed and refined the arguments she advanced in similar gender discrimination cases. The table of authorities attached to the brief contained a compendium of just about every then existing legal case, law review article, book, federal report, sociological, political, and historical treaties, and human rights documents addressing gender equality. The question presented to the court was whether Idaho Probate Code Section 15314, which provides that as between persons equally entitled to administer an estate, males must be preferred to females, denied Sally Reed, a woman, the equal protection of the law. Relying on race discrimination holdings rendered in the recent past, Ms. Ginsburg argued that the sex line drawn by the statute mandating subordination of women to men without regard to individual capacity creates a suspect classification requiring close judicial scrutiny. She acknowledged that although a legislature may distinguish between individuals on the basis of their needs or ability, it is presumptively impermissible to distinguish on the basis of an unalterable identifying trait over which the individual has no control, i.e. gender or race, and which is used to disadvantage a person as a matter of law. The Reed case was the first in a succession of cases to persuade the courts to, 1, shift the burden of proving a statute unconstitutional on the basis of gender discrimination from the person attacking the statute to the government, and 2, to deem at the outset of any analysis that discrimination based on sex was suspect, requiring the government to justify the discrimination by showing a compelling state interest was being advanced by the disparate treatment. The contributions made by Ruth Bader Ginsburg in the Reed case thrust her into national prominence. Shortly thereafter, she was offered a professorship at Columbia Law School, where she had graduated top of her class 17 years before. As a tenured professor at Columbia, she wrote the first textbook on sex and discrimination law, and later established the Women's Legal Project, which permitted her to train a generation of lawyers to pursue litigation in gender-based discrimination cases. An appendix attached to the government's brief in the Reed case identified over 800 federal statutes that contained sex discrimination language. Ruth Bader Ginsburg used this appendix to create her legislative litigation agenda. In the years that followed, she, along with her students and young lawyers, successfully challenged the constitutionality of federal and state statutes that discriminated on the basis of gender in areas such as employment law, educational law, tax law, housing, family relations, criminal law, Social Security law, wage disparity, and other areas. Her successful outcome in redefining social relations between men and women has created an enduring benefit to our American way of life. The positive impact of the life work of this remarkable woman will continue to reverberate for generations.
Hello, I am Susan Gill, and I am a judge in the Kern County Superior Court. Like most of my friends and family, I was devastated to learn of the death of Justice Ruth Bader Ginsburg last Friday, September 18. I had spent the previous morning celebrating Constitution Day with the 4th grade classes at Endeavor Elementary School as part of a project of the Kern County Bar Association Charitable Foundation. This year, the foundation donated to Kern County schools books highlighting 2 important constitutional amendments: the 15th Amendment, which guaranteed Black men the right to vote, and the 19th Amendment, which extended that vote to all women. If we must lose Justice Ginsburg, it seems fitting to lose her so close to Constitution Day and in the year in which we celebrate the centennial of the ratification of the 19th Amendment. Not many people grow up idolizing Supreme Court justices as their heroes. Instead, we choose to idolize people like movie stars, athletes, and others whose impact on our lives is not nearly so monumental as the work of our Supreme Court. Yet that has changed with Justice Ginsburg, who has become a rock star idolized by children and adults, men and women, lawyers and laypersons. The notorious RBG took it all in good humor. I am inspired by the work ethic of both the first woman Supreme Court Justice, Sandra Day O'Connor, and of Justice Ginsburg. Justice Ginsburg's resolve to work through bouts of cancer, and even up until the last weeks of her life, are inspirational to all of us. She is a tremendous role model for everyone, and especially for women and girls. I'm glad she knew she was immensely popular. I have chosen to reflect upon a civil case Justice Ginsburg identified as one of her 2 favorite civil cases, MLB versus SLJ 519 U.S. 102, which was decided by the United States Supreme Court in 1996. Justice Ginsburg wrote the opinion. The case involved an appeal by a mother from a judgment of a Mississippi trial court that terminated her parental rights to her 2 children. When they separated, the parents had agreed the children would live with their father. The father soon remarried, and he and his new wife sought to terminate the mother's parental rights so the stepmother could adopt the children. They claimed that the mother was behind in her child support payments, and she had not maintained regular visitation with the children. The mother responded with a request that she be given custody of the children because the father had not complied with the judgment, which provided for her to visit with the children. The trial court granted the father's request, but as Justice Ginsburg observed in the decision, the judge did not describe the evidence that revealed precisely why MLB was decreed forevermore a stranger to her children. The mother appealed the trial court's decision, paying $100 as a filing fee. When she was told she needed to pay additional costs of over $2,000, the mother sought relief to be allowed to appeal without paying the cost of preparing the record. However, the Mississippi Supreme Court denied her request. Without the ability to pay these substantial costs, the mother would lose her right to have the higher court review the decision to terminate her parental rights. so she sought review from the highest court in the land, the United States Supreme Court. Justice Ginsburg wrote in the decision, "Choices about marriage, family life, and the upbringing of children are among associational rights this court has ranked as of basic importance in our society, rights sheltered by the 14th Amendment against the state's unwarranted usurpation, disregard, or disrespect. MLB's case involving the state's authority to sever permanently a parent-child bond demands the close consideration the court has long required when a family association so undeniably important is at stake. MLB is endeavoring to defend against the state's destruction of her family bonds and to resist the brand associated with parental unfitness adjudication. Like a defendant resisting a criminal conviction, she seeks to be spared from the state's devastatingly adverse action." In conversations with RBG, Justice Ginsburg told Jeffrey Rosen that she was able to persuade a majority of the court that depriving a parent of parental status is as devastating as a criminal conviction. "I thought MLB was a significant case in that regard, getting the court to think about the impact on a woman like MLB of being declared a non-parent. I find it truly shocking that 3 of her colleagues, Chief Justice Rehnquist, Justices Scalia, and Thomas, dissented from the decision. Thank goodness Justice Ginsburg was able to persuade her remaining colleagues of the merit of her position. Because of this decision, no person, mother or father, will lose the right to seek review of a trial court's decision terminating their parental rights merely because they cannot pay for the cost of preparing the transcript. And this case will continue to be the law, no matter who is on the Supreme Court in the future. All parents and children, so all people, should be grateful to Justice Ginsburg for this case and for the entire body of work as a lawyer, a judge, and as a Supreme Court justice. I know I am."
Greetings, my name is Pearl Urena, and I am an educational advisor at Bakersfield College. It was a devastating day on September 18th when America learned of the news that Justice Ruth Bader Ginsburg passed away. Many admire Justice Ruth Bader Ginsburg, aka Notorious RBG. Justice Ginsburg advocated for gender equality and women's rights. Out of all the many cases that involved Justice Ginsburg, I decided to reflect upon the U.S. versus Virginia Military Institute. VMI was the first military college of the United States. It was a male-only institute. Its cadets were exposed to strict military discipline. Virginia, in the suit, proposed to create a women's institute for leadership. However, would the Virginia's creation of a women's-only admission as a comparable program to a male-only academy satisfy the 14th Amendment's Equal Protection Clause? No. Virginia's military male-only admission policy violated the Equal Protection Clause of the 14th Amendment. It was unconstitutional. This case was about breaking down a barrier. It was about an equal admission process for men and women. After the 1996 ruling of the Supreme Court of the United States, women were allowed to apply to Virginia's Military Institute. Now let's listen to a clip of Justice Ginsburg read her decision.
Decree must cure the constitutional violation. In this case, the violation is the categorical exclusion of women from an extraordinary educational leadership development opportunity afforded men. To cure that violation and to afford genuinely equal protection, women seeking and fit for a VMI quality education cannot be offered anything less. We therefore reverse the Fourth Circuit's judgment and remand the case for proceedings consistent with this opinion.
It took 160 years and Justice Ginsburg to take this case to the Supreme Court of the United States for a victorious win. Since the ruling of 1996, hundreds of women have attended the Institute. Not only have women graduated from VMI, but have also risen to leadership positions at the Institute, like First Platoon Lieutenant, Alexandria Hill. Virginia's Military Institute is not only the toughest military college in the nation, but produces the toughest women out there. I am extremely grateful that women out there have equal opportunity at VMI, thanks to the written decision of Justice Ginsburg.
The 2013 Shelby County versus Holder case was a challenge to the constitutionality of a major portion of the Voting Rights Act of 1965. The VRA was seen as one of the most consequential landmark pieces of civil rights legislation. The VRA was born out of the violence of the civil rights era. Murdered civil rights activists in Mississippi, Alabama state troopers, brutal attacks upon peaceful marchers, including a young John Lewis on a bridge in Selma. Marchers there had been shot in the back while trying to flee, as well as when they were trying to render aid to injured marchers. It's hard to overestimate, to overstate the impact, the significance of the decision. Immediately after the Supreme Court made its ruling, states previously covered by the law moved to enact new voter ID laws and other restrictions on voting, such as Texas and North Carolina. A federal court would later strike down North Carolina's law, indicating it was designed to target African Americans with, quote, an almost surgical precision. And though we may never know the exact fallout of Shelby County, many say much has been predictable. For many of the jurisdictions that were formerly under preclearance, voting has rapidly become more difficult due to voter ID laws, which experts say make it more difficult, particularly for people of color, poor people, and the elderly. And some voting laws that made it easier to cast ballots and to register have been stricken. Justice Ruth Bader Ginsburg's dissent in the 2013 Shelby County versus Holder case was said to be her most furious. It was not just filed, but it was read by the justice, which is rare. Justice Ginsburg dissents. Voting discrimination still exists, no one doubts that. But the court today terminates remedy that proved to be the most suited to block that discrimination. The Voting Rights Act of 1965 has worked to combat voting discrimination where other remedies have been tried and failed. Particularly effective is the VRA's requirement of federal preclearance for all changes to voting laws in the regions of the country with the most aggravated records of rank discrimination against minority voting rights. A century after the 14th and 15th Amendments guaranteed citizens the right to vote, free of discrimination on the basis of race, the blight of racial discrimination on voting continued to infect the electoral process in parts of our country. Early attempts to cope with this viral infection resembled battling the Hydra. Whenever one form of voting discrimination was identified and prohibited, others sprang up in its place. The court's opinion can hardly be described as an exemplar of restrained and moderate decision-making. Quite the opposite. Hubris is a fit word for today's demolition of the VRA. Throwing away preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet.
Hello, I'm Cynthia Zimmer, Kern County's District Attorney. After the passing of Ruth Bader Ginsburg, I, like many others, took time to reflect upon the role that Justice Ginsburg played on the nation's highest court. During her 27 years on the Supreme Court, Justice Ginsburg's opinions placed her among the more liberally minded justices, and she often wrote dissenting opinions that reflected her views on a wide range of issues. While I respect and pay tribute to Justice Ginsburg's public service, I also acknowledge that there have been opinions where I have not always agreed with the justice. For example, as district attorney, I am in the business of ensuring that criminals are properly caught and convicted. The decisions of the Supreme Court can have a direct impact on my ability to carry out the mission of my office and to hold the guilty accountable. One example where I did not see eye to eye with Justice Ginsburg was her dissenting opinion in Herring versus United States. That case involved the application of the exclusionary rule, which is a rule developed by the Supreme Court that requires exclusion of evidence in a criminal trial if the evidence was collected by a police officer, clearly violating a person's Fourth Amendment right against unreasonable searches and seizures. The exclusionary rule has always been controversial because at its core, it results in a trial where all the relevant evidence is not shown to the jury. The exclusionary rule was established as a measure to prevent police misconduct by denying the state the benefit of evidence obtained in a clearly unlawful manner. While I disagree on the expansion of the exclusionary rule in situations that would impede presenting the truth and holding criminals accountable, one area I found common ground with Justice Ginsburg was her understanding of the historic and unique challenges faced by women in the workplace. In Ledbetter versus Goodyear, a case decided in 2007, Justice Ginsburg wrote a dissenting opinion that showed her understanding of the unique challenges faced by women in the workplace. The case centered around Lilly Ledbetter, a female manager at Goodyear for over 20 years. After her retirement, she took action against the company because her pay was less than men who performed equal work. Ledbetter convinced a jury that not only her pay less than men, but also the discrepancy was because of Goodyear's discrimination against women in violation of the Civil Rights Act. Ledbetter's pay was adjusted every year she worked at the company, and the persistent pay differences accumulated over the years. The Supreme Court ultimately ruled that most of Ledbetter's claims for compensation were prohibited because she did not file a complaint and lawsuit every single year that her pay was adjusted. Justice Ginsburg's dissent pointed out the reality of pay discrepancy cases, which is that small injustices may not seem cause for a federal case, particularly for a woman who is trying to succeed in a non-traditional job who doesn't want to make waves. Justice Ginsburg acknowledged that the injustices in pay disparity cases are best addressed all at once, rather than requiring persistent lawsuits about the issue. While Justice Ginsburg did not convince the majority of justices in the Ledbetter case, her dissent pointed out to Congress the problem with the statute that served to block most of Ledbetter's claims. 2 years later, the Congress responded by passing the Lilly Ledbetter Act, which changed the law in the manner Justice Ginsburg suggested in her dissent. The result ensured that women who faced gender discrimination and unequal pay have the opportunity for their day in court to address historical practices like Ledbetter's case result in unequal treatment in the workplace. Justice Ginsburg was a powerful voice for women's equality and served an important role on the court in ensuring that equality issues were given a full opportunity to be heard. While I did not agree with all of her judicial philosophies, Justice Ginsburg always treated litigants, other members of the court, and those who did not fully agree with her with decency and respect. For that and her decades of public service, I am grateful.
On behalf of Bakersfield College and our president, Sonia Christian, I would like to thank all the participants and judges who shared in highlighting the legacy of RBG today. From what you saw and heard, you can see how RBG left a permanent mark on our society. From her role as a Supreme Court Justice to being a cultural icon and feminist champion, she meant many things to many people. At her core, she was about human dignity. Her legacy will continue in many ways. For one, it will continue in young college students who were trying and studying to enter the field of law, to keep equality and justice as a priority. For another, her opinions and dissent will be there when justices, both present and future, need a reminder of the core ideas that RBG, after serving the highest court for 27 years, felt were important for the nation to follow. In 2015, RBG shared the following quote in an interview with MSNBC. She said, "I would like to be remembered as someone who used whatever talent she had to do her work to the very best of her ability, and to repair tears in her society, to make things a little better through the use of whatever ability she has." Over the years, RBG has used her abilities in the field of law to show that women deserve an equal place at the table, and that no one should be discriminated against based on their gender. She strengthened women and gender equality and did much more. And after becoming the second woman to serve on the highest court that was established in 1789, this pivotal trailblazer put forth her talent and skills to make society better. And for that, we are forever grateful. Thank you for being part of our program and giving tribute to Supreme Court Justice Ruth Bader Ginsburg.